Thank you. Thank you very much, Amanda. So I am here with my colleagues Peter Rasmussen and Dennis Domblowski. Each of us has had a number of years' experience in law firms, in-house counsel, alternative legal services, publishing, a bunch of areas since law school. And then we made our way to Bloomberg Law. I'm going to show you one piece. Is this going to work? How very exciting. Amanda. A clicker that doesn't, there we go. There we go, I think it worked. This is an example of some of the analysis that we have recently published. It's just a small part of what we do, but I thought I would do a little show and tell here of some recent work we've published. One of them is a piece on recent SEC decisions, a piece on data security, and also the new credit loss standard. And even though we're not going to talk about this today, I'll just say that if any of you think the credit loss standard doesn't apply to you or your clients, you're probably wrong. It doesn't just apply to banks, it applies to any institutions that use credit, including credit cards. And if you read Peter's piece, you will find out why that's important for you to follow. So I'm going to start off with an initial question. We'll go back to this. For the raise of hands in the audience, the old-fashioned way. How many of you read specialized news publications for your work? Okay. How many of you read them on a daily basis? That's actually a pretty good number. Okay. How many of them just weekly? Just a few? And how many of just occasionally? Okay, so for most of you, the vast majority of you, it's a daily occurrence. That's interesting to know. Okay. The Ask an Analyst session, the idea here was that we requested some questions from participants, and so we got a few questions in, and the first set of questions we've grouped is around cannabis. So before we start in on this, let me get another show of hands. How many of you encounter cannabis either as part of a business model that you are working on, or a business proposition that you're exploring, or as a services provider to the cannabis industry, as a financing partner to the business industry, or in some other way? So can I get a show of hands for people who are connected to cannabis? Actually, that's pretty impressive. I would say that's maybe 20% of the room. Okay, interesting. Okay, so we got a couple of questions about legal developments in cannabis. And I am going to just make a point here for those of you who may not be as familiar. This is from the Bloomberg Law In Focus Cannabis page. It's one of our pages that we keep up on topics that are in flux. And as you can see from this very colorful United States map, there are 2 states in yellow that don't have any legislation relating to cannabis. Every other state has some combination of laws relating to cannabis. So with that in mind, I am going to hand over to my colleague Dennis to give us a little bit of general information about where we are with cannabis regulation in the United States.
Thanks, Diane. Just to level set the discussion, I think everybody knows that cannabis is a controlled substance. It is a Schedule I substance under the Controlled Substance Act. It is illegal at the federal level. But of course, we live in an environment where it's becoming much more lenient on the state level, at least. It's a dynamic situation where almost every day you hear of another state that's either legalizing marijuana for medical use or for recreational use. And as Diane showed before, we have a map that 48 out of the 50 states plus DC have some sort of legislation on the use of marijuana, many of them dealing with both medical and recreational use. There is, like I said, this is a dynamic situation. Even on the federal level, there have been developments recently. At the end of last year, there was a new farm bill that was enacted, and it contained an exemption from the CSA, from the controlled substance list, for hemp. Hemp is a form, it's a type of the form of the plant from which cannabis is grown. That's now exempted from the controlled substance list. And from hemp, there's derived an extract called CBD. I won't pronounce the word because I always get it wrong. CBD, which is now being used in drugs, beverages, cosmetics. This is now under the jurisdiction of the FDA. And I understand that they have just recently, within the past month, approved the use of CBD in an epilepsy drug for use primarily with children. On the financing side, you can go to the next. Mm-hmm. Because marijuana is a controlled substance, it's a federal offense to use, possess, sell it. Banks are very concerned with financing or supporting the marijuana business in any respect because they could be guilty of money laundering, the movement of money from an illegal activity. There are a number of initiatives on the federal level to address this. One is called the States Act, states referring to strengthening the 10th Amendment through ensuring, through entrusting the states, which would exempt any business that is in compliance with the state law on marijuana use. It would exempt that from the controlled substance list. So if you have marijuana use or possession or manufacture in a state that permits either medical or recreational use or both, then people would not be subject to the CSA at all. Banks, of course, would be free to finance that type of activity. Another initiative that most people feel has a better chance of actual passage in both houses is called the Safe Banking Act, which would specifically exempt from federal prosecution financial institutions doing business with marijuana businesses that are legal in their states. There is opposition that's expected to this, but this is anticipated to have a better chance of success than does the States Act. There is a lot of activity in this area. Since historically, the cannabis industry has been dotted with small growers, small sellers within each state. This is now changing. There are multi-state operators. This is now all being rolled up as these producers find that in order to really compete, to grow, they need to have some economies of scale. And so many of them are doing this through either joint ventures or more likely through they're being acquired by much larger entities. Some of them coming out of Canada, some of them are actually coming out of the States.
Thank you, Dennis. Since Dennis has moved from the regulatory piece to the money-making piece of the cannabis industry, maybe Peter can talk to us a little bit about what's happening on the exchanges.
Well, just a quick comment on that Dennis, your point about the legislative proposal that would remove cannabis from the controlled substances list. That would be a tremendous step forward in terms of financing. There are 3 cannabis issuers that are expected to uplist from the OTC market to either a NASDAQ or a New York Stock Exchange listing. And they would join a handful of others, but these are companies that do business primarily in Canada because the exchanges will not list a company if the activity violates federal law. It's a pretty simple proposition there, so that if that statute would become law and it would remove cannabis from the controlled substance list, it would be a major breakthrough both for financing in the industry and for the prestige of the industry. Being listed on the NASDAQ or the New York Stock Exchange, suddenly you're being followed by the analyst. You get a lot more publicity. You get a lot more press. And also, if these listed companies could be doing business in the United States, the U.S. market would dwarf the Canadian market. So it would be a very significant measure.
Yeah, and I'll just add to that. So Canada was the first country nationally to permit use and sale, and that's October of 2017. And what I would add to Peter's comment about the uplisting, they may also be uplifted, but is that there are a few companies that have been identified, at least by some cannabis and marijuana kind of market followers, as being cannabis companies. These may be familiar to you in other contexts, but there are three in particular that I noticed: AB InBev, AbbVie, and Scott's Lawn Products. So what are we talking about here? These are companies that are exploring cannabis opportunities, right? Just like so many of you in this room. So AB InBev is looking at cannabis-related beverages, as you might expect them to do. I assume that AbbVie, I don't know, maybe somebody in the room knows, but I assume that AbbVie is looking at medicinal uses. And with Scott's
My wife has some explaining to do.
Exactly. And Scott's Lawn Products, well, you can imagine that we're talking about things that grow and things that need to be fertilized. The other thing I guess I want to make a point about, just since we're transactional folks here, is that there are some reverse mergers going on so that U.S. companies can get listed on the Canadian exchanges. They're called reverse takeovers in the Canadian parlance, but it's a similar opportunity where you have a shell company or SPAC, a special purpose vehicle that you're using to go public in Canada. So the vehicles are a little bit interesting from that point of view. All right, so moving on, we also got some questions about crypto and Bitcoin exchange-traded funds. So I'm going to do another one of these show of hands. How many of you are involved in some way in digital asset transactions, either conducting them, advising on them, exploring them? Can I get a show of hands? Just a few, so less than in cannabis. Interesting. Cannabis. Okay. How many of you are exploring blockchain? A little bit more, but not a lot more. Interesting. Okay. So let's move on. So in the cryptocurrency space, we immediately jump into securities and other regulatory questions, commodity questions. So I'm going to hand off to Peter to talk a little bit about Commissioner Pierce and some of the securities questions.
Thanks, Diane. You see on the screen some quotes from a recent address by Commissioner Hester Peirce. She is perhaps lovingly known in the industry as Crypto Mom, and has been a staunch advocate of the industry, and has been a real cheerleader for bringing the industry to the fore and for having the SEC to basically get out of the way. She is very determined on this point and said that it is basically not the job of the regulator to be telling investors where they can spend their money. She's frustrated. She doesn't see that her colleagues understand the crypto market, and I'm afraid that she's correct. The SEC is not an agency that moves quickly. It doesn't pivot on a dime. And it's pretty obvious that the agency is still in the information gathering stage when it comes to crypto matters. They recently sent out an industry letter to an industry group and to some of the leading players where they laid out some of their concerns. And the points that the SEC brought out, they're very concerned about valuation issues, liquidity matters, custody concerns, arbitrage, and the potential for manipulation. It took all of this time, up until April, for the SEC to issue its first no-action letter, basically allowing a digital coin offering to go forward. And as I referred to it, it approved a transaction that basically no issuer would want to sell and no investor would want to buy. It is a transaction that was so heavily structured to be basically an Amazon gift card for the purchasing of private jet services, that it really doesn't have much import in the larger crypto market. One positive, though, to the delays, to the SEC's slow walking action on crypto matters, is that it may actually give the industry more of a chance to develop and mature. And a more mature industry, I think, might be better suited for the regulators to be able to draw sharp lines.
Yeah, that's an interesting point. Okay. Just moving on in sort of beyond cryptocurrency and the Howey test, the no action letter that Peter just referred to. So there have been some disapprovals in the blockchain and crypto space. Peter, can you take some lessons away from what you're reading in the disapprovals?
Well, I think the main concern, just going back to what I mentioned before, is that the Commission is just not ready. They don't really understand the industry well enough, and they're just looking to spend more time acquiring the necessary data in order to evaluate these transactions.
Right. Thank you. Okay, so let's move on a little bit. Sure, go ahead.
Are they separating blockchain from crypto? Those are like really two different.
Yeah, the regulatory approvals have been on the trading of ETF funds and on crypto exchanges.
Yeah.
The blockchain is a completely separate issue.
Yeah. Okay, so moving on a little bit more broadly, Peter, I want to give you an opportunity to talk about some trends in securities regulation that you're seeing.
Okay, there are three huge things that are going to be occupying my time for the next few weeks. The SEC published their RegFlex agenda, which is a list of what they might do, and included on that were the shareholder proposal thresholds. The $2,000 limit hasn't been raised in 30 years. And the regulation of proxy advisors, the possible registration of proxy advisory firms. And both of those would be tremendous issues and very controversial issues. Also, next week, the agency is going to have its vote on Reg BI, the conduct standard for investment advisors and broker-dealers.
So for those of us in the room who are, unlike Peter, are not securities experts, that's the best interest rule.
Yeah, the current standard for brokers now is suitability, while investment advisors are fiduciaries. The question is, will the rule effectively require brokers to act in the best interest of their clients? And there's also a proposal on 404B, which is the Sarbanes-Oxley certification, and the audit of your internal controls. And that would exclude more and more companies from the requirement of having to have the control system have an auditor's report on the control system, which costs a lot of money. The problem is that those companies that are going to be excluded, perhaps, from that auditor requirement may be the ones who would be most susceptible to a control breakdown. Kraft Heinz, they have a control breakdown, they survive that. Tech startup, a control breakdown, they're out of business.
So for those of you who are getting CLE credit today, you've now passed the test because you've heard of all of the technical things you need to know. All right. This is a picture of a screenshot of the piece that Peter did analyzing the recent no action letter. So for those of you who remember what the Howey test is and want to know how that works in the crypto space, you can look at this piece and you can see how he came to his decision. This is an in-focus page. I showed you an in-focus page on cannabis. This is an in-focus page on Regulation BI. As I said, these are these pages that we set up to follow evolving issues. And this has actually been up for a couple of months. We've been keeping track of what's been going on here. Let's see. So we're going to move on now to just some general corporate matters. Let me just see from a show of hands in the room, for those of you who are transactional lawyers, how many of you have negotiated a MAC clause or a material adverse effect clause at some point in your lives? Okay, so about half, maybe a little more than half. How many of you have heard of or read the Acorn versus Fresenius case? Okay, just a few. Okay, not a surprise. So one of the things that Dennis does on this channel, this analysis channel, is look at some of the Delaware Chancery cases, like the Acorn versus Fresenius case, that is the first case ever in the Delaware Chancery Court to permit a MAC. In this particular case, instead of talking about that, because actually legally it's not that interesting, even though it was a very long decision, he's going to raise an issue about anonymity in agreements. And I just am going to make a tie-in to a comment earlier that the U.S. Attorney mentioned this morning. He talked about CFIUS, looking at foreign investment review. And something that I found very interesting, because we've been following this anonymity issue, is that in his mind, at the end of his remarks, he made a link between CFIUS and wanting to know who is behind transactions, which is to say not just regulating the technology, but pulling the curtain back, and especially with so many transactions that are conducted in many layered ways, private equity or hedge funds or other kind of investment funds, that becomes a real question. Now, the old CFIUS arguably probably could have gotten there, but the new CFIUS maybe is actually regulating explicitly on this. So in a way, we can make a tie-in that, and as Dennis will say, there is a tie-in here, because these anonymity issues aren't just issues of what name gets mentioned in terms of who's on a corporate paper, who's on an LLC paper, but these are also national security issues at some level. So, Dennis, I'll hand off to you.
Okay, thank you. Those of us who have formed companies in the United States know that you don't need very much information to give to the Secretary of State's office, whether you're forming a company, a corporation, whether you're forming an LLC. Usually just the name of an incorporator, maybe the names of the governing body, if it's a board of directors or managing members, but the information is extremely sparse. The United States is being criticized internationally because we are one of the few countries that does not publicize, does not publish, does not make publicly available the identities of the real people that are forming these entities. This has been an ongoing debate at the federal level for at least the past 10 years, where various senators in particular have attempted to initiate legislation that would require those people that form companies to disclose the beneficial owners of those entities through some sort of a national database. The ABA has been steadfastly against any of these proposals, citing client confidentiality, attorney-client privilege as reasons for its stance. However, we understand that the ABA is the House of Delegates is taking up a recommendation over this summer from one of its business law sections that would change its stance on this issue and would require companies to name a contact person whenever a new entity is formed, a contact person with the responsibility to maintain a list of the true beneficial owners of these entities, and to make that information known to law enforcement, subject to a subpoena, or to other persons upon good cause shown. So it's a real change for the ABA, and it would dovetail with some of the federal legislation that's being discussed even as early as last week, recent as last week.
Thank you. Now, Amanda, we had one more last-minute question on indemnification. Should I take that?
Take it.
Okay.
We'll try to squeeze in the one from the app after that, but I'll stand here and stare at you.
So I'll try to do this quickly. This is a question that came in about the problem of developing indemnification rights when you're dealing with artificial intelligence, the problem of the black box. And I guess what I would say from the sort of Bloomberg law, from the sort of technology company perspective, One of the things about artificial intelligence algorithms is you don't always know exactly how they're working, but from the lawyer's point of view, it's really what are the results? Are the results reliable? Are they not? Can you talk to the engineers? Can you find out, is it a 50% reliability threshold? Is it a 90% reliability threshold? And are the engineers talking to the subject matter experts in an effective way so that the engineer's representation of how often the tool is correct is actually related to reality? So that's one important thing about artificial intelligence. Another piece of the puzzle is that it's about the data. So on the panel right before lunch, as they were talking about data, part of the question is not just is the data new or old, but is it actually accurate? Is it actually valuable? And when you do things with it, do you get the results that you think you're getting? So those are the sort of special artificial intelligence questions that I would start out with. Once you understand that, then we're all lawyers, then you can assess the risk and you can come up with a clever way to deal with the risk. But there is a bit of a black box problem with this technology. I'm not sure it's highly different from other technologies, but you do need to ask those questions. So, where you end up on an indemnification clause, I think, is that a lot of service providers aren't going to give you one. If you're using artificial technology and maybe your data to come up with your own outputs, Bloomberg Law wouldn't. We wouldn't give you an indemnification on that. On the other hand, if you are a service provider and you're running the show and you're scrubbing the data and you're using the technology, maybe that's a different situation. And that's not different from any other commercial transactions kind of context.
We've been getting a bit of a blinking red light, but I am going to toss this to Peter and see if he can keep it to under a sentence and a half. So a sentence and the first part with a semicolon. The question, and in fact, the premise of the question might be a bit anathema to some of the people in this room anyway, but regarding your comments about the prospect of catastrophic control failure for the startups or the very small or the not yet having expanded companies, are you saying that perhaps there might be some actual benefit to being regulated?
As a strong believer in regulation, yes.
Okay. From the company's perspective.
The question becomes, are you going to take that $250,000 that you're going to spend on an audit report, or are you going to spend it on another scientist or another tech person or something, or funnel it into the business? But that $250,000 won't do you any good if you do have that control failure and you're out of business.
Okay.
Well done.
Yeah.
All right. Thank you, Peter.
All right, and I would like to thank my friends on the corporate transactional analysis team.